I'd now like to open up the floor. We've had quite a lot coming from this side, and we would want to hear from this side. And I'm going to take the first three. Please address your issue. Let's have each person raise one issue to allow as many people as possible to intervene. And please address it to a particular person. I'm going to take the first four. And number one is Canon Omondi.
Law and language. I tend to think that law, like all other professions, has created a guild. And guild acts like a cult, which needs language within to help them understand and deal with issues and organize themselves. And this guild also need to speak to the outside world. Actually, it's created to support and assist people outside. So I'm not seeing the great problem in it creating and having its own language in this context. But the gap has been in trying to find means to communicate with outside, which Professor Mutiga rightly stated on the idea that they need for interpretation. Secondly, language is dynamic. Language is not static. Language grows. Language accumulates, acquires as it interacts. There are things that we never knew. Even if you asked me to talk about spectacles in my mother tongue, I would not know how to say it. But as language, as people interact, experiences tend to create that. And how people experience a new language, they acquire also the words with it. English got a lot from Latin, German, and all others. We then just need to find means that we would communicate what is just, what is right to people outside. That was what I think there are three areas. The cult, which is the law. Marshall McLuhan said the medium is the message. We then find a means to communicate this through interpretation. And this would be dynamic and will continue to grow.
Thank you very much. I'm taking Steve Okello there.
Be assured that the presentation is as spiritual as it is intellectually stimulating. I just want to pose a question to you, Mudomi, and maybe this also goes to the lawyers in the panel. Should we then be talking about language and law or language in law? Because listening to you, I've seen the disjunction. When you start talking about language and law, we have separated the issues. If law is the will of the sovereign as ordained, and language speaks to our culture, ideas, ideologies, our behaviors as a society, then you can see the terrible mismatch and the diminishing influence of the law or even the Constitution in reordering the transformative agenda that we want. So maybe if we reflect more on language in law, we will probably begin to harmonize that which we care for as a society, and then it will be easier to start implementing it. Otherwise, when you wear two lenses, you know, as an ordinary citizen, what you'd like to see in terms of transformation of society, promotion of public good, and then as a public or state officer, in terms of restricting yourself within the law. So then you see, you begin to manipulate the law for partisan advantage. And that's something Professor Gidungai knows very well, because having served as the Attorney General, that part of the problems of our governance is that those in positions of authority or public officers care about how to reinterpret the law, how to manipulate the law to protect or preserve certain entrenched positions. Never mind whether it's in variance with what the public want. So maybe if you could develop it further and we reach a conclusion that we look at language in the law as opposed to language and the law. Udomi.
I think right there, the Dean has demonstrated the difficulty we have with language. She says, you are at liberty to take the floor. But what she means is, you must take the floor. I'm delighted to make a short contribution. I came a little late, I apologize, but I did get the tail end of the contributions. To my mind, as a long-suffering student of the law, the one aspect of language that has bothered me is the fact that language is not value neutral. And I think my very good friend, Dr. Muthoni, made this point very well. Language is a purveyor of values and attitudes and insights and perceptions and settled wisdom. And nothing demonstrates this better in this country than the story, looks like yesterday for some of us, a long time ago for some of you, maybe for some, a story you've never read. There was a very distinguished barrister here in this country called S.M. Otieno, who was very good at the criminal defense bar. And one afternoon, after he had smoked a cigarette, the chariots came for him, and off he went. And we would have thought that that was going to be a very simple matter. It was not. The whole country, for several weeks, was in the throes of a debate about where he could be buried. Injunctions were flying left, right, and center. And there was a huge drama. And at one point, the case turned on the question, what is the difference between home and house? And very learned and erudite lawyers pronounced themselves on this topic. There was a very good judge, in my judgment, who'd been here in Africa a long time, who, when he first had the matter, dismissed it within 10 or 15 minutes. His name was Harold Platt. Was it Platt or Shields? Huh? My memory says Platt. Dr. Kamau's memory says Shields. We'll go with Platt for now. The matter was then referred to the Court of Appeal, where I think Nyarangi J.A. and Bosire, and I think, no, Kwach was arguing the case. And for several days, the case took an entirely new dimension. And poor Harold Platt was attacked for his failure to understand basic African values as expressed in the language of the African people. So to my mind, even as we write things in the new constitution and into other laws that give meaning to that constitution, we must remember that the very nature of that language carries presuppositions about it. I was involved for very many years before I went to Sharia House in reforming family law. First as a consultant, then as a member of a task force, then in government. And I thought there was a section on the rights of women that could brook no controversy. That men and women have the same rights before, during, and after marriage. I can tell you now, as we sit here, there isn't greater controversy in the area of family law than what that sentence means. So I think this dialogue we are having is a good opportunity for us to reflect on how the law is given meaning by a language which itself is not value free, is not value neutral, and which comes with a lot of baggage. Thank you.
Thank you very much. I had seen Van's hand up. Vance, and then Dr. Muli, and then a hand there.
Thank you, Prof. My name is Vance Wekesa. I'm a student of law at the University of Nairobi. And I have a question directed to Professor Mutiga and Mr. Mahat, kindly. And on this particular question, I'm asking about the ambiguities in law. So I've not had any of the panelists talk about ambiguities as being an aspect of language. And my question is, at times there are drafters of the law who leave certain clauses or sections as ambiguous as they are, or in any contractual agreements. You go reading them and you find it's ambiguous. And of course, the law has tried to come out with ways to redress these ambiguities. Say, for example, the ambiguities would be against the person who's actually made them. But then, in drafting the law and in understanding the law, how do we approach ambiguities as a question of language in law? Thank you.
Okay, we have Dr. Muli.
Thank you. I'll take up from where Vance left. You know, ambiguities in law are there and they're provided for sometimes, whether it's in the Constitution or in a legislation, deliberately or not. Deliberately because you want to leave some room for application on different circumstances, and sometimes it's not intentional and therefore it leads to a lot of litigation. For lawyers, they make a lot of money going to court to persuade the court that you need to interpret that ambiguity to mean what I persuade you to mean. And so for us lawyers, it's important to rely on the rules of language, but within a certain context. And I think the discussion we've had here today has emphasized that right from the experience in Turkana, from the Samburu regarding what justice means in their society, as well as with regard to the fact that a word is imbued with values. Those values come from a particular context. The canons of interpretation in law actually require lawyers to look at both the ordinary meaning, but also the context and also the purpose. Now, I'll give you an example, even as I direct my question to the lawyers on the panel, regarding what they see as the role of interdisciplinary study of law in informing the meaning that we can give to the words that are used in legislation. In 2014, there was police recruitment done by the National Police Service Commission, an institution established under the Constitution. As Professor Muigai has said, there were laws that were enacted to give effect to a constitution. That was based on an interpretation and a meaning given to what is in the Constitution, and then it was put in the legislation. So the recruitment happened, and petitions were filed because it was found that that exercise had irregularities, there was corruption, etc. The decision in the High Court and Court of Appeal hinged on one particular issue, and I think Mahat gave a similar example, on the meaning of the word committee. If today I ask you what a committee means, you think of funeral committee, wedding committee, yeah, all sorts of committee. And it was interesting how the court dealt with the issue of committee. And the meaning, for example, that the learned judge gave was, look, because the Police Service Commission, yes, it had power to establish committees, established a committee that didn't have a representative from the commission, and therefore that was an illegal committee. That's the version of a committee, that actually a committee should constitute members of the commission. If you read the actual provision in the law, it does not say that it should be constituted as such. If you look at ordinary dictionaries on the meaning of the word committee, I think out of about 6 I read, only one says it may have members of the body that has created the committee. But the judge decided to fall back on this understanding. And I looked at it and thought, so did they look, because this is about a committee in a corporate body. I could have given any number of legislation that showed the usage of the word committee in law. And there are some that say, actually provide that this body should have a committee on recruitment, a committee on etc. This didn't. How did the judge fall back on this particular definition? Why didn't they think of the commission as a body corporate that is being given powers to set up administrative components of how it will do its work? Now, if they had gone to the law of economics or organizational economics, maybe would have a different outcome. So I just want to put it out there that indeed there is, it's so important today that we have that link between language and law. As Professor Mbote said, we don't need to teach them separately. But in determining these meanings, is there a need to have an interdisciplinary study of law so that we are able to consider the different values and meanings we can have to words? Thank you.
Momondi Okech, I'm a professor of associate professor of applied linguistics. I want to talk about, just give a few comments and follow up on what Professor Mutiga was talking about. I begin by saying there is nothing unique about law. There is nothing unique about mathematics. There is nothing unique about witchcraft. As a matter of fact, all of us have challenges understanding the language of witchcraft. We have challenges understanding the language of hockey, if you're not a player in the hockey field. If you do not play football, you do not understand it. And therefore, I believe every profession has its own unique register that they will use. And if we have to communicate, then we must make conscious effort to ensure that we understand one another. But since law as a profession also signals uniqueness in status, lawyers tend to use language that would signal them as experts. And therefore, they will go in and use the difficult language of jurisprudence, jurisdiction, and all the other languages that they use, or words that they use, which are not unique, as a matter of fact. There is nothing difficult about jurisprudence. Just like if I spoke Dholuo, which is my first language, and talk about Gage, that I use, or Ndai, then you wonder, what is wrong with this fellow? So what am I saying here? What I'm saying is this. Language is the key thing here. And law, to me, in terms of interpretation, laws are rules that govern us. And since they make sure that there is order in our society, and language is what helps us to socialize, each one of us should then be able to use language in a manner that aims at communication. In other words, let's use words when we purpose that we should be understood. But I know one thing about lawyers, because I've been teaching legalese for quite some time now. And when Professor Mutiga was talking about the borrowing from Latin to law, there is always the idea of economics. Who wins cases? And how do you win a case? You must put up a good CV. And the CV involves using words that not everybody understands. And sometimes I really wonder whether the magistrate or the judge actually understands what is going on, or they are busy nodding and taking down notes, and then later on they tell us that, hey, this case has been judged in this manner. Look at the way they even craft the judgment. And as a linguist, sometimes I read judgment and I wonder, what are we doing? Are we aiming at communicating? So law to me is about logic. It's about logic. But then as linguists, we really need to work on the interpretation, which, and my last point is, when we interpret words, we are at the purview of semantics. We are at the purview of meaning, and meanings are chimerical. People disagree on the meaning of words. While I understood clearly what Justice Quach was saying, even as a young boy in high school then, when he meant there is a difference between a house and a home, I understood it very well coming from cultural orientation of the Luo. And indeed, there is a big difference between home and a house. Somebody else may have wanted to interpret it differently so as to win the case that was at hand. Thank you.
So now I'd like to give our panelists, starting from Mahat, just a minute intervention, your final word on this issue, so that we can move on to the next panel.
I think there's only one question which was directed. And by the way, my intervention is that if you see a lawyer using very difficult, difficult words, and that's a very poor lawyer. I mean, I was trained by Peter Heim and Oliver Fowler, and my first day of pupillage, I was told to do an opinion. It was 1 page, and I was told if you cannot say it in 1 paragraph and in simple English, you will not be able to say it in a page. So the best of the lawyers are not the ones who you see on TV giving opinions on that. The best court lawyers are the people who are very simple to the fact and who don't use very complicated language. I think that's, and Professor Guido Muigai will bear that out. That is one. The second bit is the issue of the ambiguity of the language that the law uses. I mean, if you are a trained draftsman, sometimes people use ambiguous language in certain provisions for obvious reasons, right? To give a bureaucrat or someone who's performing certain functions some wiggle room to be able to do certain things, right? So for policy purposes, we have legislation, we allow certain discretion to certain people so that they are able to do certain things, and that's how the language is. If we were very restrictive and very prescriptive, it will mean every other time an issue came up, then someone has to do legislation to amend that legislation. So sometimes we are able to do that, and the law caters for that when you're interpreting. So, for example, in contract, there is a rule they will tell you, they will call it contra proferentum rule, that if there is an ambiguity in a clause in a contract, and you are the party who wants to rely on it, okay, then you have to prove that actually that the whatever clause said is what the meaning you want to give it to it. So the court will interpret as against you, and you have to bring evidence. And sometimes there is nothing wrong in ambiguity. It allows for the development of the law, for the development of the language. But sometimes we are very prescriptive, especially when it comes to tax legislation, when it comes to criminal legislation. We have to be very, prescriptive and specific, and we don't want any ambiguity because those are penalties or negative consequences to the party, and we're very specific. And the courts, the way they interpret that is whenever there's a tax legislation, whenever there's a criminal legislation, we always interpret in favor of the party who the government wants to actually enforce against. If it's not specific, if this is ambiguous, then the court will of course do it for the benefit of the other party. I think Kello mentioned it should be law in the language, law and language, or law in the language. I always wanted to say, and I have been trained, and I have also trained people, and I can tell you this for certain. Very few people, because very few lawyers actually are very good linguists. Lawyers don't understand, most of them, the think tanks of because you're using, for example, first of all, the basis of the law is the English language. I mean, remove all this gibberish about jurisdiction and all that. I mean, if you remove all that, the basis of the law is the English language, just the way the basis of engineering is mathematics. I mean, you have to be able to do whatever you have to do. So two things come up. It's very easy if you are giving an annotation for a patent or for anything to use the language of engineering and mathematics. I mean, it's more exact and all that, right? If you try to say whatever you're trying to say in engineering and mathematics using using language in general, it's very difficult. It's generally difficult. So my sense is the basis that actually legal practitioners or people who are training lawyers should start with is to ensure, first, those lawyers are trained well in the normal, simple English in the verbs and the syntax and all that before even you come to the legal writing, because that has to form the basis. So what generally happens is people go to law school and they are bombarded with all these things, and the lawyers think these are very cool stuff, and they write and you cannot even be able to comprehend what they are writing. So the basis is, whether it is in English or Swahili or whatever language that they are being trained on, is to first train these people in the normal English, simple English syntax, whatever it is, the verbs and everything, then move from there to the specialized legal language, which is not much. I mean, 90% of the legal language is just ordinary, reasonable English. It's only 10% which is a bit complicated, and that's my...
Okay, pass it on to Professor Iraki.
I think I liked the idea of an interdisciplinary approach to the issue of law, because we saw there are disciplines like linguistics, like pragmatics, that can help also in unpacking some of the ideas. For us, in terms of ambiguities, we disambiguate from a linguistic point of view by using the context. And the context could be what has been said, what will be said after. Context is also a cognitive idea. It's the shared beliefs between two people. And as long as the context is shifting, the meaning is shifting. So you can see from our point of view, as linguists, we have another way of disambiguating sentences. My final shot would be to maybe consider, in view of, with an eye to the future, 50 years to come, 100 years to come, as we urbanize, what languages are the young people speaking? What will they be speaking? How will you deliver justice? And I think we need to have a broader approach to issues of law, think about promoting African languages. I'm delighted that there are institutions that offer interpretation from English or French into Swahili, but what about inter-African translation? We may want to look at that a bit more seriously. When you talk about Lusophone, Anglophone, Francophone, or Sinophone countries, we are kind of glossing over facts. If you say Kenya is Anglophone, what percentage of Kenyans understand English? We might want to unpack these things a bit more seriously through research to understand, when you deliver justice in English, what public are you addressing? How many people can understand you because you're using English? Thank you.
Just to respond on the issue on ambiguity, and briefly, that in language and in linguistics, to disambiguate, we clarify the context, or we align the context. There are other ways. In fact, there are many ways. Another one would be where we use variants, and variants would include giving a description instead of terminology. Instead of using terminology or a certain vocabulary, you then would describe or explain. And also you could use equivalents in terms of synonyms and the like. And lastly, you could use style, where style here could include grammar, things like punctuation and so on, that would disambiguate what the issue is. And in linguistics, we take ambiguity very seriously, because ambiguity determines meaning. So when drafting law, then the drafter would perhaps need to pay attention to language use and certain things that would mix up the intended meaning. I have my last say, and my last say has to do with the language of the Constitution of Kenya, in this sense that the Kenyan Constitution 2010 did give us a direction on the languages of the country and declared Kenya officially bilingual with Kiswahili and English, in that order, being the official languages of Kenya. I have raised this issue at the University of Nairobi Senate, where, that being the position, Kiswahili has still not been given its place in the training of lawyers at the University of Nairobi. I don't know what the situation is in the other universities that train lawyers. And I would like to say that as scholars and as lawyers and linguists gathered here, this is a question we need to engage with. If we continuously complain that we don't have equivalents of riparian in Kiswahili, we don't have equivalents of this and the other, we perhaps are not thinking in terms of language growth, language planning, development of terminology, and so on. There isn't a language that in itself is able to carry a technical discipline without that language being deliberately developed. In the devolved governance in this country, the language that is being used in the county governance, and I have visited several doing a certain research I am currently doing, is actually Kiswahili. The county, are they called parliaments? Assemblies, yes. Do business majorly in Kiswahili, then they write that in English. We need to seriously think about the place of the Kenyan lawyer vis-a-vis the languages that are spoken in this country, and Kiswahili is there. It just needs corpus planning and deliberate growth for it to be able to deliver. Thank you.
Professor Abuya.
There was a question on ambiguity. I think that's the one that Vance raised. I really doubt whether in the professional world there is any contract that will be drafted with ambiguities in it. The example that Mahat gave was things about discretion, and that's really a different conversation. I think the ambiguity you mentioned is when the contract then is read, but I really doubt in the professional world whether somebody would draft a contract and know that this contract is actually ambiguous on question X, because the contract will be exchanged. On the interdisciplinary that Elizabeth mentioned, true. Yeah, lawyers sometimes they put themselves on a pedestal and think that we are the people, and then the rest really don't fall anywhere. But of course, interdisciplinary brings a lot of not just experience, but learning on the different issues that you talk about. You may look at it from this way, but of course, the people in other disciplines will have different perspectives on it. And I found it very interesting in my work to look at history and literature, just as ways of even understanding how other disciplines interpret the same issue. So clearly, yeah. On whether it's law and language, law in language, language in law, and also the question of whether it's a house or a home, my take is always less is more. Yeah, just less is more. If you want to use the Latin phrases and etc., eventually it is whether you're communicating. And if your audience is a very, very basic audience, you better use language that they understand. Otherwise, you get lost in translation. Thank you.
Thank you, Professor Abuya. We'll now have Dr.
Okay, thank you, Professor Patricia. Probably what I would like to re-emphasize is that language is dynamic, and knowledge is equally dynamic. When we look at the history of language, the history of the English language, in the 1400s, there was so little vocabulary that was in the language. But over time, it has grown, and some of the words that existed before have been dropped as we get new ones. During that time, there was so much use of the Latin language in the English language, which currently we are not using. I tend to think that that should also apply in the legal profession, in that as time goes, we need to see change in terms of how the language is used, because what we need to look at is the needs of the people who are being served by the language in law. So if the contention is in the word shall, is it a big deal to have a look at it and use a term that is more convenient to the people that need it? If when we use I don't know how to pronounce it, amicus curiae or whatever. So you realize that when that was used, that was the most searched term in the social media at the time. So if you used a more simpler term that could be understood by everyone, could it be a problem? So my question is, what if we do not have to do it at the same time, but what if we keep revising the way we use language in law to fit the needs of the people who are being served by it? So that is one question. And another thing I wanted to re-emphasize, of course, is the role of linguists in the legal profession. Is there a way these two professionals can work together? Because when you're talking about interpreting a language, so you don't write it and interpret it yourself because you'll interpret it the way you wanted it to be. So what if the linguists are involved? I'm sure in other countries, the lawyers and linguists work together in terms especially of trying to understand what has been documented. So that is my concern. Is there a way we can work together? Finally, when we teach English, or we look at it in terms of the purposes that it's meant to serve. So we call it English for specific purposes. And when we teach according to the class, the purpose, the function of that, whatever we want to do. So if I'm going to give a speech to primary school children, I will tailor my language to fit that particular group. When I'm speaking to professionals, I'll speak as though we are equal. So if lawyers are serving people, some of them who have not gone to school, is there a way you can vary the way you use language so that it meets the needs of that particular person or the different classes of people that we have? Thank you.
For me, 3 quick things. If we agree that language is not value neutral, then the consequence is that perhaps 99.99% of what we call our laws are not actually our laws. They are British or English laws that we've been lying to ourselves, because if language is not value neutral, then those laws represent English values, English norms, English experiences, English heritage, and whatnot. And therefore, it could be possible. We've been all living a lie all these years, talking of the laws of Kenya for Kenyans. Point number 2, it is amazing for me how language and law can actually be disconnected. And I'm responding to Ogola's question whether it is law and language or law in language. One of the little known secrets, if I want to shock you today, going by the Supreme Court decision Mahat, from a purely grammatical point of view, the Supreme Court decision of 2013 was the correct decision. And the one of 2017 was actually, from a linguistic, technical, grammatical point of view, the wrong decision. Why am I saying this? If you read carefully the relevant things about publications about the two decisions, you will find that going back to the Ballot Act of 1872, perhaps this is one of the few cases where "and" is disjunctive and "or" is conjunctive. And some of you may have seen a presentation by Professor Prempe on this, where he says that from a purely grammatical point of view, the court actually made the correct decision, only that it was a coincidence. No one even knew. And I want to show you the problem here is that what language is telling us might not perhaps reflect the value that the drafter of that legal provision
wanted the law to espouse. The third and last point is about the interdisciplinary approach. I am one of those who believe that our society would be richer if the training of law was more disciplinary, and if we perhaps abandoned our trade union approach and allowed even non-lawyers perhaps a bigger place in the table. And why I say this, it amazes me. I practice law in so many tribunals, the NEMA tribunal, the procurement tribunal, and what shocks me is that we're willing to trust people who are not lawyers to make very important judgments in these tribunals. But when it comes to mainstream judging in our courts, all the way to the Supreme Court, it suddenly becomes a guild or a restricted club for lawyers. I've been teaching my students to cease to be carpenters. And I've been telling them the difference between carpenters and engineers and architects is, whereas the engineer will know and the architect will know why this building is designed this way, why the column is made using whatever material, the carpenter only knows how to read the plan and say you use Y10 gauge of the steel bar and you put the stone there and the other place. But if you ask them why we are using the Y10 bar and not the Y12 or the Y24, they have no clue. You would need the architect to know why this column is that thick and the other one has a different thickness, and how that relates to the soil structure, how it relates to the environment, how it relates to the weight of the building and its intended user. A carpenter only knows that the window is supposed to be there, the door is supposed to be there. For me, the beauty of a multidisciplinary approach is that it helps. It gives us a cadre of lawyers who just don't know that the law is very clear, and Section 83 means this. They actually appreciate from a multidisciplinary point of view what would be the consequence. Why does it say and not or vice versa? And until we get there, I'm sorry, our laws will not be serving us very usefully.
Thank you very much, Mwalimu Diankolu. He taught me very well, and I'll pick up from where he has left. I'm just supporting interdisciplinarity and encouraging lawyers to venture out and collaborate with the other experts in other disciplines, because coming from literature background and now in law, my area of interest is law in literature. And since I agree with my teacher entirely that the laws we are having are not our laws. Our laws are in our literature. If you want to train about a kangaroo court, you don't have to go far. Just take Ngugi wa Thiong'o's trial of Dedan Kimathi and look at how Ngugi mirrors a trial in a colonial court of a freedom fighter. And if you want to train on family law, then just take Achebe's Things Fall Apart and look at the trial and how it goes there in a language that all of them understand and in a context that is familiar to all of them. So I do believe that even in our courts as we try now, some of the persuasive elements in our judgments come from African proverbs. And when we use them appropriately, they convince us that even though we use a strange language, we can really root them in our own experience. So I encourage us to open up even to geographers, to sociologists, even to those who are in the area of space, engineering. I was reading, I think last week, Americans are concerned that there is a Chinese satellite that is in the space and it seems to be hunting for American military satellite. In case they meet and there's a crash and they land somewhere in Kenya, how will a lawyer handle that? I think we need to engage with engineers and know all this, because the castle that has been separating the law from the society, I think, is coming down, and we should celebrate it. Thank you.
Just to jump off from what my co-panelists have said about the role of interdisciplinarity, which Dr. Muli raised, I think there is certainly, like they have said, a need for the discourse both in lawmaking with other disciplines, but also I think importantly in the training of lawyers, so that we foreground, I think in any law school you will find that law students take what are called common courses very lightly. But it would be important to foreground those and make them more targeted. Perhaps we ought to take more classes in philosophy or in anthropology or sociology or African literature and so on as a core part of an LLB degree, and that would make a lawyer who has a broader context than just the legal training. My final remark was going to jump off the requirement by Council for Legal Education now that students being admitted to the LLB program either have, to the undergraduate law degree, either have a B in English or Kiswahili, and then we proceed to teach the entire law, of course, in English and practice it in English. But, you know, just if delivery of justice is important and if the language of the court and the language of either the accused, Professor Mutiga talked about, are different, what would it look like then to have the language of lawyers change a little bit? And last week, some friends, lawyer friends of mine and I were talking about this issue, and somebody drafted, you know, something very short in Sheng, and I will read it to you. I am not a native Sheng speaker, so you will bear with me. And it says, "Ni ukweli, Your Honor, ni venye nikiunda hii notice of motion, niliforget kuweka ka request ka stay of execution. But Your Honor, mistake ya counsel haifai kudhuru client. Si jambo poa. Kwa hivyo, Your Honor, ile prayer na kuomba ni ukubali tu hii application with costs. Mimi niko too obliged." So, I mean, I think if we're going to take the idea, the language ought to evolve and to change, and it ought to espouse our laws, it's important to think about what this might really look like and what it might mean in the arena of justice. Thank you.